Good afternoon. Hi, good afternoon. On behalf of the American Constitution Society and the Center for Democracy and Technology, I'd like to welcome you to the Microsoft Ireland case. Do U.S. warrants work in foreign lands? I'm Debra Perlin. I'm the Director of Policy and Programs at the American Constitution Society. Founded in 2001, ACS is a national network of lawyers, law students, judges, and policymakers who believe that the law should be a force to improve the lives of all people. ACS works for positive change by shaping debate on vitally important legal and constitutional issues, such as the ones we'll be discussing today. Internet platforms and social media enterprises are ubiquitous. We use them to write correspondence, conduct financial transactions, shop, take photos, and keep in touch with family and friends around the world. They contain treasure troves of information about our lives. Building off of the Supreme Court's case earlier this term in Carpenter versus the United States, at its core, the Microsoft case is a question of when and how the US government should be able to access that information. The Microsoft case began when the US government served a warrant on Microsoft directing it to turn over information for an email account. Microsoft complied insofar that it turned over records that were stored in the United States. Citing a long-established presumption that that U.S. law does not apply outside the country, it refused to provide the contents of those emails that were stored in Ireland. The question before the court is, does the 1986 Stored Communications Act, the legislation that the Department of Justice relied on when it served the warrant on Microsoft, and a law that was enacted before there was the modern internet, apply extraterritorially? After the U.S. Court of Appeals for the Second Circuit answered that question in the negative by ruling for Microsoft, in an opinion that highlighted how antiquated the Stored Communications Act was and how ill-prepared courts are to weigh the competing interests at stake, the Supreme Court agreed to hear the case. We are fortunate to have a panel of experts here with us today to discuss the case and what its implications may be. To moderate this discussion, we have a good friend of ACS, Amy Howe. Amy is an independent contractor and reporter for SCOTUSblog, where she previously served as the editor. Before turning to full-time blogging, Amy served as counsel in over 24 merits cases at the Supreme Court and argued 2 cases there. Additionally, she has taught at several law schools, including Stanford, Harvard, American, and Vanderbilt. Please join me in welcoming Amy.
First test in this technology case. Thanks for inviting me, and thanks to all of you for coming. Those of you who follow the Supreme Court know that this is a big term for blockbusters by any definition, and we're here to talk about one that has the potential to be a blockbuster not only legally, but also in terms of public interest, because everyone uses email, even these days, the Supreme Court justices. And so we've got a terrific panel that ACS has put together to talk about the case. Just to give you the game plan, we're going to spend about an hour with these folks talking and responding to some questions that I have to them, and then we're going to save about 15 minutes for your questions before Senator Coons arrives. So I'm going to introduce our panel quickly and then move on to the first question. So on the far left, we have Alex Berengaut, who's a partner at Convington and Berlin and is counsel to Microsoft in this case. Next to him is Jen Daskal, who's an associate professor of law at American University's Washington College of Law, and has also served as the counsel to the Assistant Attorney General for National Security at the Department of Justice. On my left is Greg Nojeim, who is the senior counsel and director of the Freedom, Security, and Technology Project at the Center for Democracy and Technology. Before that, among other things, and all of these folks have very long and distinguished resumes, so I'm just giving you the highlights. Associate Director and Chief Legal Counsel of the ACLU's Washington Legislative Office. And then to his left is Sharon Bradford Franklin, who's the Director of Surveillance and Cybersecurity Policy for New America, and has also served as the Executive Director of the Privacy and Civil Liberties Oversight Board, an independent federal agency. I'm going to throw out the first question to our panel, which is that the Supreme Court traditionally decides to hear cases that involve some sort of division among the lower courts of appeals, with the idea being that it's going to resolve this question once and for all so that different laws do not apply differently in different areas of the country. But the courts of appeals were not divided on the legal question presented in this case. And so what, if anything, does that tell us about why the justices took the case and how they might rule? And just think we're just going to let you all jump in whenever you're so inclined. Push to talk.
Sure. So, I think that it's a great way to start this out, but I think it gives a chance to kind of highlight the importance of this case, and obviously the Supreme Court recognized it by the fact that they took this case without there being a circuit split, which is highly, highly unusual. And as probably everybody in the room knows, the result of the Second Circuit, or as was already discussed, the result of the Second Circuit ruling is that law enforcement can only access data that happens to be located within the territorial boundaries of the United States. And I am assuming that the Supreme Court was persuaded by the writ for certiorari that was filed by the government and the government's concerns that this posed some very significant burdens on their ability to access data in lawful investigations when they had gotten a warrant based on probable cause, simply because the data happened to be located outside the United States, including in situations where the U.S. government was investigating a local U.S. resident for a local crime. And I think this was in particular, as the Supreme Court was made aware in the briefs, was less of a problem with respect to Microsoft because of the particular way that Microsoft organizes its servers, but a very big problem with respect to some of the other providers, in particular Google, which moves data around the globe in a much more distributed manner, and the government was encountering a number of cases where, for example, it was investigating a child porn case, and some of the emails would be in the United States, but the photos would be outside the United States, and the U.S. government was therefore unable to access that data.
On the other hand, the court could have waited until one of those other cases, one of the Google cases, came up, and then taken both of the cases together so that it could have a more complete factual record. It didn't do that. I'm not sure what that means, but it seems like it could have, it might go toward how it ends up deciding the case. It might decide the case based on the facts in front of it, which is more static location of data, as opposed to reaching out to factual situations that aren't in front of it.
Just the follow-on to Greg's point is because it doesn't have that complicated fact pattern in front of it, posed by how Google stores data, for example, this should be an easier case. And I don't want to jump ahead too far and get Amy mad at me, but I think that everybody looks at this case as really the predicate to a congressional debate. However, it's resolved because there are so many complicated issues that are not in play in this case that really need to be picked to Congress. But I'm getting ahead of our time.
Yeah, we will talk about possible legislative fixes during the Q&A, and then we can also, of course, bring it up during your questions.
Yeah, I think I largely agree with what Jen said. I mean, without having a view on the merits, I think when the federal government, joined by some states, says that this is an urgent public safety issue for the court to consider, I think the court treats that with a lot of respect. And so without thinking how they were going to decide the issue, it makes sense that they would, in these circumstances, want to take a look at it now.
I think Sharon's answer set up perhaps my next question kind of nicely, which is at this point to sort of take a step back. This is not the first time in recent years, it's not even the first time this term that the Supreme Court has had to apply old laws to new technology, as I think was mentioned in Carpenter versus United States earlier this term. They had to apply another provision of the law, in this case, the Stored Communications Act, to the cell site data records. And so it was enacted at a time when very few people had heard of, much less had cell phones. And you can sort of look back over time at some of the other cases that involve old technology, or old laws, new technology, and sort of how have the justices dealt with these cases in the past? Sometimes they've been criticized as not always being the most technologically savvy bunch in Washington.
Yeah, but but they're coming out the right way. Look at some of the recent cases. Kylo, that was the case that involved heat lamps for marijuana plants in a house. Question was it a search to detect those heat lamps using a device that wasn't commonly available to consumers and it could reach inside the house? Court says, yes, that's a search, you need a warrant. Jones, the GPS tracking case where they put the GPS device on the car and they tracked the car for a number of days while it moved around on public roads. Government said, hey, wait a minute, it's on public roads, so you don't need a warrant. Court said, no, you need a warrant. There was a trespass as to the property. Riley, where the issue was cell phones taken from a person who was arrested, and the question the court had to answer was, does the search incident to arrest doctrine, which generally means that they don't need a warrant to search the thing on the person as they are arrested, court said, no, cell phones are different. They have so much data stored in them, they should be treated differently. You need a warrant for that. That suggests a court, I think, increasingly sensitive to how technology is being used in our lives and how the Fourth Amendment has to adapt to technology. I don't know that it also kind of dictates a result in this case, though, where the question is not more about is the data sensitive or anything like that. It's about, does the warrant reach the data when it's outside the United States? But I think we can say the court understands technology perhaps better than it did in the past.
I'd like to pick up on that. So in the cases Greg was just discussing, and the most recently, of course, being Riley with the you need a warrant to get the data on the cell phone, and Carpenter with the location information, where based on the oral argument, we're cautiously optimistic that there'll be a similar result. That's the court looking at how does the Fourth Amendment apply in the digital age. Let's look at this doctrine that initially was based on papers in the home and look at what is comparable. What does it mean when we have this digital data where so much information can be on a phone, where so much can be gleaned from consistent continuous location tracking over a period of time. So the court has shown a real ability to say this is what the Fourth Amendment means in the digital age. But this case, the Microsoft Ireland case, it's not a constitutional case. We have, the government actually got a probable cause warrant. There's no dispute. They were able to meet that constitutional standard. And here, it's really, the government is trying to raise these policy concerns about the interests of law enforcement, and it gets into a lot of complex, how do you draw those lines? When the data is stored this way, when it's stored that day, there's competing international norms. It's not a how does the Fourth Amendment apply in the digital age. So I really don't feel that the court can solve this case, and we feel we've filed an amicus brief along, OTI and CDT joined a coalition amicus brief in support of Microsoft's position in this case. But however the court rules, it's not going to really be able to address all of those complex policy considerations here in a way that it could resolve those questions in Riley, and that we hope it will in Carpenter.
Yeah, I mean, I would just add, I agree with the way that Greg described, particularly Riley, as the justices recognizing what's new about digital evidence. And I think in this case, the key question here is not a Fourth Amendment question, but the key question is, do you apply kind of the old standards to this new type of not just technology, but internet architecture? So under traditional rules of international law, and this is a big piece kind of underlying Microsoft's position in this case, it's not permissible for law enforcement agents to unilaterally go into another country and conduct a search or seizure on that other country's soil. You need the permission of that government in order to do so, or that government will conduct the search and seizure for you and send the information back. Here, what's different, though, is that Microsoft is based in the United States. And so the key question then is, do those old rules still make sense? Does that application of that kind of norm make sense in this case where nobody's actually crossing a border? The government's not crossing a border to seize the data. Microsoft's agents and employees aren't crossing a border to seize the data. They can access the data from within the United States. So Microsoft asks the court to look at this much like you would look at a situation where an agent actually has to cross a border, and the government says, no, this is different. You guys can access that from within the United States, and we need a different rule set to reflect that reality. So I do think that the court is going to have to struggle with a question as to how new technology, new architecture applies in thinking about how to understand what this case really means and whether or not this is or is not a permissible extraterritorial search.
Yeah, from my perspective, the fact that this case is a question of statutory construction and not a question of constitutional construction like the cases that Greg mentioned is absolutely pivotal, because for constitutional cases, it's really only for the court to decide what the Constitution protects. But for statutory construction cases, it's the court's role to construe the statute. But of course, Congress can enact new statutes. And the principle that is at the very center of this case, at least from Microsoft's perspective, is that when you're dealing with internationally themed regulations that have effects outside the United States, the pivotal principle of statutory construction is the presumption against extraterritorial application, which means that you resolve ambiguities, you presume that Congress didn't intend for statutes to have effect outside the United States. And so not only is this a case where Congress could weigh in and address the issue, our position, our view has been that because of the presumption against extraterritoriality, that should be how this case is resolved. And Congress should address the issue, and in the meantime, the court should abide by this principle of construction, which would limit the reach of the statute to what's going on just inside the United States.
I would just add that I think all parties in this case agree that the presumption against extraterritoriality applies. The question is whether or not the action takes place outside the United States based on where the data is located, which would violate the presumption against extraterritoriality, or, as the government says, the relevant action is when the data is disclosed to U.S. law enforcement, which happens within the United States and therefore doesn't violate the presumption against extraterritoriality. And it, again, and I completely agree with Alex, it calls for Congress to step in and resolve this, because Congress just wasn't thinking about this when they passed the statute back in 1986, and I hope we can talk a little bit about the Cloud Act that was introduced, I think, 2 weeks ago now.
Yes, we will definitely get to the Cloud Act, but sort of picking up on your remarks, sort of one of the other sort of sub-legal debates is sort of what is the focus of the statute? You know, this idea that the presumption against extraterritoriality generally applies. Everyone agrees that it does. And so then one of the other debates is what is the focus of the statute? And the government's argument is that it's disclosure. There's an argument that I think for Microsoft that it's actually user privacy. And so I guess the next question is, what is the focus? And if Microsoft wins, is this a victory for user privacy?
So the government's position is definitely, as you say, that the focus of the statute is on disclosure, and they maintain that because the disclosure happens inside the United States, that there's no extraterritorial application of the statute here. I wouldn't say our view has been that the focus of the statute is on user privacy in the abstract, but rather on the privacy of stored communications, communications in storage, which is a theme that runs across the key operative provisions of the statute at issue, which is the Stored Communications Act. And the statute does a couple of things. It protects communications in storage against hackers. It criminalizes hacking stored communications. It tells providers you can't disclose your communications in storage except under certain circumstances. So it protects against providers divulging communications in storage. And then the section that is at issue here tells the government you can only get communications in storage under these circumstances. So I think that the combination, the combined effect of those provisions in our view, leads to the conclusion that the focus of the operative regulated conduct here is the protection of communications and storage. To your point about whether a victory for Microsoft is a victory for privacy, in some sense, the privacy interests here have been addressed by the fact that the government got a warrant, which, as we've said, requires a finding of probable cause. But there is a sense in which this case is about privacy, and Microsoft is trying to vindicate customers' privacy rights, because part of the argument and part of the reason for the presumption against extraterritoriality is that our laws should govern here, and other countries' laws should govern in other countries. And when Microsoft argues that the presumption means that warrants should reach only customer data stored in the United States, the implication of that is that the laws that govern customer data stored in Ireland are Irish laws, and it makes sense for Ireland to be able to regulate according to its privacy norms the data that is stored in its country. So I think in that sense, a victory for Microsoft is a victory for customer privacy, because it allows customers' data to be protected by their privacy laws.
I think that's right with a caveat. So when people say the case is not about privacy because the privacy interest is handled by the fact that there was a warrant issued in the case. And remember, warrants require probable cause, which is the highest amount of proof you have to have in U.S. law. And it's a very high amount of proof compared to what other countries require as well. And that because there was a warrant, the privacy interest was satisfied. I try to look at the big picture when I think about this case. If the United States highest court says U.S. law permits the U.S. Government, and by the way, state governments too, to reach into data that's held in other countries and then bring that back to the United States using U.S. legal process, what's the rest of the world going to do? Are they just going to say, oh, that's okay by us? I don't think so. I think what the rest of the world is going to do is say, well, our legal process works for data that's stored in the United States. And the way the large U.S. tech companies are headquartered in the United States and store a lot of data in the United States, there's a lot of data here to which those rules would then apply. And a lot of other countries do not have the same rules that the United States have. They don't have an independent judge making the decision about whether the data should be disclosed. They don't have something like probable cause. They'll have something, a lot of countries have reasonable suspicion or another level of proof, but probable cause is generally seen as pretty high. So if we say our process works abroad, you can bet the rest of the world is going to say its process works here.
Greg pretty much said what I would have said as well, that while in this case for this user we have a finding of probable cause based on U.S. law, this really, a finding in favor of the government really would be an invitation to other countries to try and do the same thing and reach across borders. And so for privacy overall, for all sorts of people who store their data with U.S. providers, and U.S. providers are holding a lot of data for a lot of folks all around the world, their privacy interests would be threatened, even though you did have a probable cause standard met in this particular case.
Yeah, I just wanted to take it back to something that Alex was talking about, which is, as the court is going to have to, because everybody agrees that the presumption against extraterritoriality applies, then figuring out whether this violates the presumption requires the court, as Alex said, figure out what the focus of the statute is and whether the relevant action took place in the United States or outside the United States. To be totally honest, the government says the focus of the statute is on disclosure, and they make some arguments about that. Microsoft says it's about security of stored communications and make a number of arguments about that. I don't think it's a clear-cut answer. I don't think there's a obvious way to resolve that dispute. I think Microsoft has a slightly higher hurdle, because if Microsoft's right that it's about the security of the stored communications, it's not entirely obvious that that infringement on security or infringement on privacy occurs where the data is located as opposed to where the data is disclosed to the government, which happens in the United States. So there's some risk from Microsoft's position that even if they convince the justices that the answer is security of stored communications, the relevant action takes place in the United States anyway. But I think then that gets into, that requires the court to really assess to some extent what ought to be a congressional job, the job of legislators. What are the underlying policy implications here of what happens in this case? And I think the privacy issue is complicated because it's pretty clear, as you've heard, that in this case there was a warrant based on probable cause issued by a judge. And the result of Microsoft's position, the Second Circuit's ruling, is that in order to get access to that data or any other data that happens to be outside the United States, the U.S. government now goes and makes a request to the foreign government. And we just heard that all those foreign government standards are often, in most cases, if not all cases, lower than U.S. standards. So that data is accessible based on lower standards than would be protected as if the U.S. were getting the access to the data based on a warrant issued by a judge pursuant to probable cause. But so I think the privacy gains are to some extent questionable from a Microsoft win, but I also share, and this is again why I think a more nuanced response to this that requires congressional legislation is so important, that there are important privacy implications of a government win. And as I think Sharon just mentioned, there is a risk that a government win is both perceived by foreign governments as the U.S. saying that it can essentially access data all around the world without regard to local considerations, and that that's used as a green light to say, as long as you have a local-based provider or a subsidiary in our country, we're going to try to access data all around the world, including in the U.S., including of U.S. citizens, according to our own standards. And if that's right, again, this is a prediction about the future. We don't know what's going to happen. But if that's right, there is a risk of an erosion of privacy for all associated with a government win as well.
I just also wanted to address the point about the dispute between the place of disclosure versus the place of storage of the data. And I realize that a lot of that is couched in terms of, looking at parsing the words of the statute, but the government, in its argument on this point, says, really the privacy invasion happens when Microsoft would turn over the data, and that would happen in the United States. But that doesn't make sense to me. To me, it's when this is a government seizure. That's why we needed the probable cause order. Microsoft is basically acting as the government's agent in collecting this data and seizing this data for the government, and that is happening in Ireland. It reminds me a little bit of in the surveillance context where some people argued, well, when the government collects data in the first instance, that's not really a privacy invasion. It's not a privacy invasion until some agent of the government actually looks at the data. And again, I just fundamentally disagree with that. I think at the point of the seizure, at the point of the collection for the government, that's where that privacy invasion happens.
Turn to something that Jen alluded to, which is the idea that there is another avenue for the U.S. government to get data from other countries. And Alex can correct me if I'm mischaracterizing Microsoft's argument. One of Microsoft's arguments is that there is such a channel. They're called mutual legal assistance treaties. And so I was hoping that one of you or one or more of you can talk a little bit about exactly how they operate and what the different arguments are on each side about why they are or are not enough to solve the problem in this case.
Yeah, I'm happy to start. That's right. The data, the customer data in this case, is stored in Ireland, and there is a mutual legal assistance treaty between the United States and Ireland, and it's undisputed, and the government has never denied that they could get this data if they wanted to by making a request under that treaty to the government of Ireland. The government's argued that that's not a long-term or global solution to their problem because that framework is slow and cumbersome, and there's not a mutual legal assistance treaty with every country in the world where a tech company might store data. They haven't introduced evidence to that effect in our case, and in our case, really the only evidence about the Irish MLAT treaty is that it works pretty well. But if you set aside what's in the record in our case and turn to the broader policy debate about MLATs, I don't think anyone would argue that the MLAT process couldn't be improved, and some of the legislation that's been introduced with the support of the tech community would improve it in various respects.
So, two things. One is, could the MLAT process be improved? The other thing is, with improvements, would it be adequate? Okay, I think we have to, would it be adequate? Could it be improved? Clearly. What improvements have happened already? One improvement that hasn't really been taken advantage of was that MLAT requests can now be centralized here in the District of Columbia. And DOJ asked for more prosecutors and more judges to be able, magistrates, to be able to deal with an increased volume of MLAT requests from abroad. And to do that, they needed money. We, in the privacy, a lot of privacy groups signed on to letters that originated with tech companies seeking more money for DOJ to do more MLAT requests so that we could make this problem a little smaller. Congress didn't appropriate that additional funding. There are other things that could be done, like standardizing the types, the way that demands are made, making those demands electronic. Some of them are actually done by paper, which takes a long time. A lot of the problem that foreign governments have when they make demands is that they don't provide enough information to meet the U.S. probable cause standard. And that could be because either that information doesn't exist, in which case one would say, well, maybe that information, the data shouldn't be disclosed. But if the information does exist and they just don't know how to marshal it and put it in their MLAT request, well, that's a problem that could be solved by educating the requesting governments. My view is that even with improvements, because of the volume of crimes that involve electronic evidence, we would probably still need to have some supplemental system to make these demands. That the MLATs, they need to be there. There's countries with which we don't have MLATs, and they need to be more efficient, but it's hard to see that system scaling up to the quantity of demands that are being made now by foreign governments.
I fully agree with what Greg just said. I think that if you look at if you look at charts about the number of requests for digital evidence and digital evidence across borders over the last several years, it's like an exponential upward tick. And the system, no matter how many improvements, the system can't handle it in a sufficiently efficient way for the needs of legitimate law enforcement. But I also think there's another question, another underlying question as to when is it appropriate to engage the MLAT system? And in my view, it doesn't make sense to say that a government, the U.S. government, should have to use the MLAT system simply if they're investigating a U.S. person for a U.S. crime, U.S. citizen for a U.S. crime simply because the data is located overseas. The MLAT system is designed to respect the interests of foreign governments, their legitimate interests. But it's not at all clear to me, and this is not necessarily the facts of the Microsoft case, because we don't know the citizenship of the target, but it's not at all entirely clear to me why the Irish government ought to have any say if the only hook that the Irish government has is the location of the data. That what ought to matter if you're thinking about designing an MLAT system is making sure that it's reserved for situations in which the foreign government has a legitimate interest in setting the rules governing access to the data. And it seems to me that for principles of democratic accountability, that should be tied to things like the nationality and the residence of the target, as opposed to things like the location of the data.
All right, I think we want to go ahead and talk about the Cloud Act, since you've been sort of tiptoeing around it. So I'm going to ask you all to explain the Cloud Act, what it does, what the provisions are, how it would affect the Supreme Court ruling, but sort of to also keep in mind that the Supreme Court's going to hear, I'm not an expert on the Hill, I don't know sort of where the legislation is. Maybe you all will talk about that. The Supreme Court's going to hear oral arguments in this case in a couple of weeks. They're going to vote that week, and then someone is going to start, they're going to assign the opinion, and someone's going to start writing the opinion. They need to have that opinion done by the end of June. And so I think that for purposes of this case, I think that probably everyone, whether it's the tech community or the justices themselves, would really like to see Congress perhaps resolve this issue, but I'm not sure that it's a given that Congress can resolve this issue in time for the Supreme Court's decision by the end of June. So take it away.
So I'll just start by describing the Cloud Act. It really has two parts, and the first part, as Amy just said, would effectively, if it were passed before the end of June or before this opinion came out, it would moot the case because it resolves the key issue in the case. And it basically says, and I think in a very nuanced and helpful way, it basically says, as I've already argued, that the location of the data shouldn't matter. If the U.S. government has a warrant based on probable cause in the investigation of a crime over which there's jurisdiction, they should presumptively be able to access that data. But it preserves in certain circumstances, and we can get into the details later, it preserves in certain circumstances the ability of tech companies to move to quash on the grounds that the target is a foreign national and that government has a certain agreement with the United States. And then it sets out a number of factors that the court would consider. It's a form of statutory comedy analysis, things like the location of the target, the nationality of the target, the relevant interests of the two governments. And to me, those are exactly the right criteria that ought to be looked at in those types of situations. And it's taking a step to both ensure that law enforcement has access to the data it needs and to reflect a foreign government's interests in potentially setting the rules governing its own foreign nationals. And I should also say that this possibility of raising this motion to quash only exists when there's a conflict of laws, so that the U.S. effort to get access to this data conflicts with a foreign government law. The legislation also explicitly, via a savings clause, but at least explicitly mentions the availability of common law comedy in other situations where this new statutory mechanism isn't available, and therefore kind of, in my opinion, puts its thumb on the scale and seems to suggest, kind of nod to the importance of doing this kind of analysis if there's a conflict of laws and if the target is a non-U.S., as a foreigner located abroad in all kinds of cases. And I think it's important to note that both Microsoft and the Department of Justice, the two opposing parties in this case, support this legislation, as do a number of other major tech companies and others.
Just a quick question. This is not the first time that this legislation similar to this has been introduced, or was there earlier legislation, but it was slightly different?
The earlier legislation was slightly different. So yes, this is a kind of an update to other International Communications Privacy Act, other pieces of legislation that have been percolating for some time. There's another piece of the bill, which I'm sure we'll get into some discussion about, that deals with a kind of converse problem that we haven't talked about, which is a provision in U.S. law that prohibits U.S.-based companies from turning over communications content to foreign governments. So it's creating the converse problem for foreign governments that the Microsoft Ireland case is creating for our government. So UK government investigating a local crime involving a UK resident wants access to email accounts associated with that crime. Turns out that the email user, who's a UK citizen, is using Gmail. They go to Google and ask, pursuant to their process, to get that data, and Google says we can't turn it over to you under US law. You have to go through the mutual legal assistance treaty process. And we have better data on our own processes than we do on foreign government processes. That takes an average, as of a couple of years ago when the requests were lower, that takes an average of 10 months for the US to comply with these requests. Foreign governments are frustrated by this, the bill provides a mechanism to deal with this in a limited set of cases. So if a foreign government enters into an executive agreement with the United States based on a determination that that foreign government meets certain human rights and rule of law standards, that foreign government can, in very specified circumstances, make direct requests to US-based companies for the data of foreigners outside the United States. So if that foreign government wanted access to my data as a U.S. citizen, it would still need to go through the mutual legal assistance treaty process, and the U.S. government would ultimately have to get a warrant based on probable cause before it could turn over that data back to the UK or any other foreign government. But if the foreign government wanted access on their own citizens in connection with a local crime, it could make a request directly to Google or Microsoft or Facebook, but subject to a number of criteria. Like there has to be review or oversight by a judge or other independent authority. The request has to be particularized. It has to be lawful under the foreign government's law. It has to be in the investigation of a serious crime. It cannot be used to violate, to infringe on speech, and a number of protections designed to also ensure that the foreign government's not either directly or incidentally targeting U.S. persons. There's, I think, dispute on this panel about this part of the bill. In my view, it's a real opportunity for the United States to respond to the concerns, in my view, the legitimate concerns of foreign governments, but do so in a way that kind of raises the bar and responds to those concerns and sets baseline substantive and procedural standards. And the alternative is that foreign governments get increasingly frustrated and find the kinds of unilateral ways to access this data that Sharon and Greg talked about before, without the U.S. having any say whatsoever in terms of what those standards are.
Sharon agrees with you that there is real dispute on this panel.
Sure. Let's take the second part of the bill first. That's the part where the foreign governments are making the demands. The way to look at this is that you're basically swapping out U.S. law, which requires a warrant and probable cause, for the law of the foreign country. Now, Jen likes to stress the instance where the foreign country is demanding data about its own citizens. That's not what the bill talks about. It's the foreign country demanding data about anyone except a U.S. person, okay? So think about small countries. Countries where a lot of the people who might commit crimes in the country aren't necessarily nationals of the country. Do we want to have a system, which this bill would provide, where these countries would be able to reach data no matter where it's stored, no matter who it's about, provided it's not about an American, and get that information because they'd be able to go to U.S. providers who have a worldwide user base. That's how to think about this legislation. And when I think about that, I say to myself, well, what do I want that foreign law to have so that people around the world are as protected as they are now under the current system, or close enough, right? You'd want judicial authorization, right? The bill doesn't require judicial authorization. The bill says that there has to be supervision by an independent entity. Doesn't have to be judicial, doesn't have to be an authorizing entity. It could be a different kind of supervision, like what the US DOJ says happens in Section 702 surveillance. In 702 surveillance, the FISA court never approves a single target, and yet the government says it's judicially supervised. What else would you want? You wouldn't want a country that engages in torture to be able to get this information and use it to torture people, right? Bill doesn't prevent that. Bill says that whether a country engages in torture is just a factor to consider in whether to give it worldwide access to data about people. There are a number of factors that the Department of Justice would be required to consider. None bar the Department of Justice from entering into the agreement with the foreign country. In addition, there's nothing that ensures that the Department of Justice is going to act in an objective manner based on what the statute says, as opposed to cutting a deal with another country and entering into an agreement because the politics make it right. And let's be honest with ourselves. We have an administration where politics with foreign countries counts. And we have to have mechanisms in this legislation to make it so that the countries with which the United States cuts these deals and gives the country access to data on a worldwide basis has solid criteria and that they are enforced in a way that we can be confident rights will be protected. And we don't have that right now.
Could I just jump in on one quick point, and then I'll, which is, I'd resist the notion that this bill would give any foreign government worldwide access to a provider's data, or indeed access, period. The bill doesn't compel providers to turn over any data to foreign governments. Providers, if this were passed into law, would have exactly the same rights to resist a foreign demand that they would have before the bill were passed into law. All this does is lower a bar under U.S. law that would prohibit the provider from otherwise complying, and in place of that introduces these protections that Jen described. So there is a push and pull there, but it's a push and pull solely with respect to a barrier that previously exists under U.S. law. If a foreign government wants to make a request to torture, then a provider could contest that request, and to the extent that it imposes a conflict on the provider, here there are protections for the provider to have recourse to the courts, as Jen described as well.
But Alex, with all respect, the provider will often not know what is the nature of the crime for which the data is sought. It just won't know. It'll get a demand to disclose the information in this account. It might recognize from the name of the account that there's something sensitive that was in the news that suggests they should make the disclosure, but they often won't know. And also from the foreign government's perspective, their law applies. Alex is saying that it's voluntary by the provider. It is voluntary under U.S. law, but from the foreign government's perspective, it's mandatory. And the foreign governments are starting to do things like arresting executives of U.S. companies in order to compel this kind of conduct. They could do that going forward under this legislation. Let me mention one other thing. The legislation says that the orders must respect free speech rights. It doesn't say whose version of free speech rights have to be respected. Under the legislation, there's no reason, if a deal was cut with the government of Poland, which just passed a law saying it's a crime to say that Poland was involved in the Holocaust, if they have passed that law, if they demand that data and there's a consequence to that. There's a potential consequence to that. And that is that when the U.S. is seeking data from other governments, it doesn't necessarily need a warrant. And why is that important? Because the statute doesn't say that they need a warrant. The providers, to their credit, are interpreting a constitutional case involving an American, involving a search in the United States, to say, hey, a warrant is required, and so we're applying this warrant standard across the board. Under this legislation, all of a sudden there's a distinction between U.S. persons and other persons outside the United States. And so it's not clear to me that a provider would have standing to push back if the government came to them, U.S. government came to them without a warrant seeking content for a person abroad.
All right, Sharon, I'm going to let you have the last word on this, and then we'll...
Thank you. So I share all the concerns that Greg raised about this bill, but just starting out, as Jen outlined, there are the two halves, and they are indeed addressing a real problem. I think all four of us agree that the mutual legal assistance treaty process is slow, cumbersome, not up to the task, and the two halves of the bill address, as you heard Jen describe, the different sides of this. When the first part addressing the Microsoft Ireland case, when the U.S. wants to get data that's held outside the country, and the second part of the bill, which I want to focus on more, is when other countries are trying to bypass the mutual legal assistance treaty process and get access to data held here by U.S. providers. And under the current system, although it's slow and cumbersome, it is very rights protective. If another country wants to get data held here, the request is reviewed by the Justice Department, that goes before a U.S. court and meets a probable cause standard. and they are reviewing each of those requests to protect the rights involved there. This structure in this bill would bypass that, and while the companies would have the ability to, protest, it's all on them. And this bill does not even require that the predicate bilateral agreements, right? So the structure is first, the other country, the first out of the line is going to be the UK, will enter into an agreement with the United States and have this bilateral agreement, which is reviewed entirely by the executive branch. They have a lot of discretion to approve it under standards that are not mandatory, just factors to be considered. No congressional approval required. And so we're relying on that, where there's so much discretion in the executive branch as the predicate. And then after that, that country can go straight to the provider with the request. And the provider won't necessarily know what the facts are behind this request. So if they're going to do this in this kind of a structure, we need to make sure that they are really building in robust safeguards for individual rights. We want to see robust safeguards in terms of the review of the bilateral agreement and the standards by which it can be approved. We want to see robust standards in what is required. What are those safeguards? Greg referred to the review at the front end. If DOJ and a U.S. court are not reviewing it, we need to make sure that that foreign government has independent prior judicial review of those requests, that's what we're relying on to protect the rights there. So a lot more work needs to be done to build in those safeguards into this structure to protect the rights of consumers in order to make this process one that would not be vigorously opposed by a lot of civil society groups.
So I was given reprieve to respond very quickly, but I think there's like a couple of different layers that this discussion is taking place. But one is I see it as a normative question, which is what's the U.S. role in controlling access to data of foreigners sought by foreign governments simply because the data is U.S. held. And I think that's a big source of whatever one thinks about that for foreign governments. It's a huge source of frustration. And so one of the things to consider is not just current law versus a change in current law, but kind of a longer time horizon. And the reality is it's incentivizing all kinds of efforts by foreign governments to get around these restrictions, including mandatory data localization laws and unilateral attempts at access. And once that happens, once we move to that world where foreign governments can directly access the data themselves without having to worry about these restrictions, the U.S. gets to say nothing about what those standards are. So I personally think we are at a particular moment in time where we as the United States have a chance, by virtue of the fact that so many of our tech companies hold so much of the world's data, to try to come up with a harmonized solution to this and do so in ways that raise standards. We also have to be realistic. If the standards are set that are so high that most foreign governments can't meet them, then we just recreate the same problem. So in my view, I think, obviously I would love to see every single government have the most robust privacy standards in the world, but we're not there. And I think we have to understand the reality we live in and the incentives that both exist and that we're creating. And just as one anecdote, as Sharon said, there's a draft agreement with the UK that would almost certainly go into effect pretty quickly after this legislation is passed, if it's passed. And the UK, for the first time ever recently, it's enacted a provision that allows for some judicial review of its equivalence of warrants. And when you talk to UK officials, they will tell you that one of the reasons why they supported this new judicial review provision is because they knew that this was in the works and they knew they wanted to be eligible for these types of agreements, and it provided an incentive to them supporting something that they had never supported previously. Now, I understand it's not perfect. There's concerns that the judicial review provision is not as robust as ours, but it, in my view, is a change in a positive direction and the kinds of things we should be encouraging.
It's been a spirited discussion of the Cloud Act, and we can certainly continue it during the Q&A. But I want to take a step back and pretend for a moment, I know it's hard, that the Cloud Act does not exist. The Supreme Court, as I mentioned earlier, has to decide this case by the end of June. And I'm going to channel Justice Stephen Breyer here. Is there some sort of middle ground that the court could reach between, the U.S. government can always get the email records no matter where they're held, and the U.S. can never get the email records that are outside of the country? Perhaps, and again, we're pretending that we don't know about the CLAD Act, some sort of statutory comedy analysis that might...
Unfortunately, I don't think really the Morrison framework gives the court that doctrinal opportunity. The framework talks about the necessity of establishing the focus. The parties have laid out two completely different explanations of what the focus of the statute is here. And the court's conclusion, I think, is going to follow from which of those two roads it follows. As Judge Lynch on the Second Circuit said in this case when it was before that court, that's an unsatisfying choice because there are going to be policy consequences that are advantageous and disadvantageous no matter which of those two paths the court takes. But for precisely that reason, I think the presumption against extraterritoriality would suggest the court should resolve that choice in favor of the set of issues that limit the statute to the territory of the U.S.
I agree that the court is presented with two pretty stark choices, and I completely agree with what Judge Lynch said and what Alex just said about the value and the importance of having Congress engage. I do think there's ways that the court can write a more nuanced opinion. I've written about this before, but assuming the court rules primarily rules in favor of the government and says that the location of the data doesn't matter, what matters is the location of the provider, it still can, in its opinion, take steps to remind the lower courts of the importance of engaging in what we've talked about a lot here, a comedy analysis, if and when the target of the investigation of the warrant is a non-citizen located outside the United States and a conflict of law exists. It's a doctrine, it's a common law doctrine that the executive already claims that they take into account in deciding when to issue warrants, that courts should take into account in deciding how to evaluate motions to quash. And so I think that there are things that the court can do to kind of put its thumb on the importance of a robust engagement in that kind of analysis to take steps to take into account the interests of foreign governments here.
I think that makes a lot of sense in the case of a government victory to have the court signal something about comedy analysis, because I don't think there's been a case involving electronic communications yet where it has done that comedy analysis. At least I'm not aware of it. So I think that would be helpful. Now, if it's going to decide for Microsoft, one thing that it could do would be to make it clear that it's only addressing the factual situation in front of it, where data are stored on a pretty static basis, and not try to and make it clear that it's not issuing a decision that addresses other factual situations where data is moved around a lot or sharded. I think that would be a helpful thing as well.
I agree that the court can and needs to decide the case narrowly. The fact pattern before it is fortunately more straightforward and does involve static data held in one known location. But however it comes out, there are going to be so many remaining open questions that Congress is going to still have to address.
So it's going to depend a lot on what the court's opinion actually says.
Well, why don't I start with the parade of horribles of all the bad things that happens if the government wins. So I think a victory for, and a lot of them are things that have previously been mentioned in connection with the importance of legislation and the long-term perverse incentives that it's intended to address. But one thing that will follow from a government victory is reciprocal actions by foreign governments that place American privacy rights at risk. So if the U.S. government claims a right to by virtue of its power over a company in its jurisdiction, to compel that company to take customer content that's stored in a different country, bring it here, and hand it over to the government. What moral standing will we have? What legal standing will we have, our government has, to complain when a foreign government that is willing to use the levers of power over U.S. affiliates in that country to summon them in and say, hey, we want you to take some data you've stored in the United States relating to a U.S. Journalist or government official or human rights advocate and bring them over here and give them to our government. And by the way, we're not doing anything really different than the United States government is doing under your own Supreme Court decision. So I think that's one drawback. Another drawback is the effects it will have on the global internet. The companies that will benefit from a government victory are foreign tech companies that will seek to differentiate themselves by saying, hey, we're not subject to U.S. jurisdiction, so if you store your data with us in our country, then it's beyond the reach of U.S. providers, and foreign governments may mandate that data be stored with those foreign companies, and that will in turn lead to, I think, long-term counterproductive effects to the openness of the internet. So those are two problems with the government winning, and I'll leave it to others to share all the wonderful things if we win.
I mean, I share the concern about the incentives it creates for foreign governments, and particularly, and they're not just hypotheticals. So, Belgium in particular has a very aggressive assertion of the extraterritorial application of its laws. Brazil does. We've already heard about an executive that was hauled off to jail. So they're not hypotheticals, and they're real concerns. And this is why this case is so hard, because there's problems with either side winning. I think a Microsoft win has a much creates a very strong incentive in favor of data localization and mandatory data localization laws that I think are quite concerning, because the result of a Microsoft victory is that the location of data controls, and so it's both a means of controlling access to all kinds of information about one's own citizens and residents and anybody else that one's interested in, but it's also a means of protecting data from the reach of U.S. government. Data localization laws, I think, in my view, have a range of negative consequences, from security consequences, privacy consequences, and economic consequences in terms of the impact on the growth of the internet and really the growth of innovation as well. So I think that's a big concern. And the other obvious concern, which we've already talked about, associated with the Microsoft victory, is just the security costs that the U.S. law enforcement would face if they are unable to access data that they have a legitimate basis for accessing and a lawful basis for accessing just because the data happens to be overseas.
So if Microsoft wins a broad victory, I think the first thing that will happen is the Department of Justice will be swarming this building and every other congressional building, seeking to reverse that case, that decision very quickly. And I would guess that Congress would act, and hopefully in a nuanced way, but I think there'd be enormous pressure for Congress to step in. If DOJ wins, I think it's a lot like Alex said, that there's going to be a lot of pressure from foreign governments to insist that their process works in the United States to compel data, including data about Americans. And I think it would be very difficult for the U.S. to resist, and I think it'd be real chaos if it actually came to pass.
So I'll just say that we believe Microsoft should win, and if Microsoft does win, I agree with Greg that the pressure on Congress to act will be much, much greater. So that is assuming, not something I want to assume, but if Congress is able to do so in a considered way, taking into account all the interests that need to be taken into account, including robust safeguards for consumers' rights, that will be a good thing, because there are so many issues in play here that deserve that considered attention by Congress, but in a way that is rights protective.
Excellent. Well, we have time now for your questions. Do you have a microphone or? Okay. So, questions for our panel? Can you translate GDPR from the uninitiated?
The GDPR it's the EU's kind of mega privacy and data security regulation that's going into effect in May of this year. So I think the biggest kind of interconnection between this and the General Data Protection Regulation, or GDPR, is the question of that's not really been presented in any case to date. So Greg mentioned earlier that while, many people have called for more robust comedy analysis in these cases, including me, there haven't actually been any cases where any providers come forward and said what U.S. government is demanding with respect to data overseas actually causes a direct conflict of laws. Nobody said that in this case even as well. But there is, I think, an open and unresolved question based on how you interpret a variety of transfer positions in the GDPR as to whether requests, if the government wins, whether warrants that demands production of data that's regarding EU citizens or EU stored data, bringing it back to the United States would violate some of the transfer restrictions in the GDPR. So some of those conflicts cases and the need for the kind of comedy analysis I've talked about is much more likely to arise once the GDPR goes into effect.
I think about 8 of the amicus briefs went into whether a disclosure by Microsoft in this case would violate the GDPR, which goes into effect in May. And I read them all, and I wrote about them in the SCOTUSblog, and I think the answer is it's not clear, which when you think about it, it's really amazing because they drafted this knowing about this issue. There's one article, Article 48, which actually talks about saying, it says that the disclosure pursuant to a foreign court order has to be under an MLAT or a similar agreement. Well, that's not what's happening in this case. So then you have to look to other parts of it to see, is there a derogation from Article 48 that's permitted? Well, then there's Article 49, which has a couple of circumstances that scholars and the European Commission itself split on whether those derogations in Article 49 would save this disclosure. So I think it's an unresolved question. I'm surprised that it's unresolved because it's really important and it was easily predicted. And it's really important because a violation of the GDPR by a company can result in a fine of up to 4% of its assets, which is a big number for a lot of these companies. So that's where we are.
I mean, just one comment on what Greg just said. The risk is manifest. I mean, even the commission, which took a more tempered view in its amicus brief, as Greg said, didn't say that U.S. unilateral legal process would categorically fall within one of these exceptions in Article 49. What they said is it's conceivable that they could. And so even the commission's view is that there needs to be a case, more case-specific analysis here. And given the penalties at issue, I think that just imposes a tolerable risk of conflict and just massive exposure to U.S. tech companies.
Or the need for new bilateral agreements.
Do we have other questions? If you could come to the microphone so that they show up. But I have also been told, unfortunately, that Senator Coons will not be joining us. They scheduled a series of votes starting at 2:30, although I don't know whether any of them were on the Cloud Act. I assume that they were not. And then we could all just go watch.
So you're stuck with us.
All right, well, yeah, terrific.
Hi, my name is Danny Sepulveda. I served in the last administration, and I led a delegation to the International Telecommunications Plenipotentiary Conference in 2014. And a colleague from India raised a resolution arguing that the ITU should create a standard, an international standard by which Internet Protocol communications that either exit or enter a country have to be copied and retained in that country. Specifically for this reason, because India has real challenges going through the MLAT process to get data here. As a progressive and a Democrat, I believe that we should use the power of our markets to improve the rights of people worldwide. I fully agree with that. it will be extremely difficult to argue that the Indian government should be able to access evidence stored in the United States about crimes committed in India only if it meets evidentiary standards that are concurrent with American evidentiary. So my point here is that I think that all of you agree that whatever happens in this case, it's a bad outcome, that it'll have negative implications on incentives around the world for behavior. So as Joe Biden said, don't compare me to the Almighty, compare me to the alternative. The Cloud Act serves, I think, from a progressive perspective, as a powerful alternative to an outcome in this case without a legislative resolution. So my question to you is, as an organization for which I have an immense amount of respect, is the standard by which you would support something like the Cloud Act that before an executive agreement could be reached, a country like India would have to have laws and procedures to protect non-Americans, the question then becoming, is it the role of the American government to protect the consumer rights of non-Americans in India? But let's agree that what we're going to try to do is influence an improvement in law. What is the level at which it's realistic to expect that we can force the change in domestic law in India to meet our standards in order for them to enforce their own law? We've tried this in trade. And in trade, what a country like Colombia or Peru gets in exchange for changes to labor and environmental laws, access to our markets. Here, what they get in exchange is the right to enforce their law. And that creates very difficult conversations internationally. And I would agree strongly with Jennifer that if we don't manage this very carefully and legislatively with respect for foreign governments and their sovereignty, that it will have real effects for data localization laws and do so quickly.
So the question is, what do we do about India? And the other question is, what do we do about Brazil? What do we do about China and Russia? What do we do about them? And I think there's two. Let me just back up. I'm not saying that they have to have the full U.S. rules when it comes to surveillance. I don't think that we'll be able to export our rules to the whole world. What I do think is that there is enough international consensus about what the standards ought to be for electronic surveillance that we can articulate those in the legislation. And they're not there now. They're not there now. And again, what is there now are just factors. So take India. What are the minimum things that you'd want a country to have to do in order to make the direct demands? Because remember, the country can always avail itself of the MLAT route when there is an MLAT agreement. So keep that in mind. I think you'd at least want there to be judicial authorization. You'd want there to have to be strong evidence that there was a crime and that the information being sought was relevant to the crime. I think you'd want there to be a requirement of particularity. I think that's in the legislation already. I think we can articulate what these things are that the government ought to have to meet based on international human rights standards. And then there's going to have to be decisions. Does the government meet them or not? And I think those decisions have to be ones that the rest of the world, as well as Americans, can look at it and say, well, that decision makes sense because we have these facts about how that government performs. Should the criteria that the Department of Justice is employing in reaching that decision, should the facts that it relies on be a part of the public record? I think so. Should human rights groups get a chance to comment when the government says, oh, I think we want to enter into an agreement with India? Should there be an opportunity for people to say, well, here's what India ought to do in order to qualify for such an agreement? We heard already that the UK, its judicial review provisions adopted, I think, 2 years ago, were in part influenced by wanting to get into this process. I think that it makes sense to set a bar that is reasonable and that is based on international human rights law.
If I could just add on to that a little bit, two caveats. First of all, it's not totally removed from the interests of Americans, because there can be what we've learned about as incidental collection, right? There can be communications with Americans in what is captured by the foreign governments. You can't target a U.S. person. It has to be you're targeting a non-U.S. person under this legislation, but you could have collection of communications of Americans. And it's also not limited to where that foreign government is seeking information about its own citizens and a crime that was committed on its own soil. The legislation is not limited in that way. And then finally, I do want to echo the point that Greg just made. You know, as Jen pointed out, we do have incentives created here, and that's a good thing. And even if we're not urging mirroring full U.S. protections, we want to get those standards up. And the UK, in my understanding, with their Investigatory Powers Act, now likely could meet a standard for prior individualized judicial review. So that's a good thing.
Thank you. Any other questions? All right, well, please, thank you for coming, and please join me in thanking our terrific panelists.
Does its absolute best to bring the Stored Communications Act into the 21st century. If you think about the technology every one of us had, those of us who were alive then, when, what was this, 1986, it was a dramatically different world. And the idea that the law that governs access to electronic data needs to be updated since 1986, when I had just graduated from college, and the idea of the internet or email was a distant glimmer not yet developed, it seems obvious to me that we would wait until the Supreme Court makes law in this area, as they may imminently do, seems foolish. I think it's more important thus that we put together the Clarifying Lawful Overseas Use of Data, or CLOUD Act. We use lots of really cool acronyms here in the Senate. What I like about it is that it strikes, in my view, the right balance between privacy, predictability, and security by explicitly requiring that countries meet baseline privacy, human rights, and rule of law standards before they can enter into an agreement with the United States. My hunch is this will be a closely defined universe of countries with which we will enter into data sharing agreements, and that it will clear the way for a more respectful, balanced, and appropriate way for us to pursue national security goals while still doing so within confines and structures that protect privacy and that ensure appropriate limitations on the risk of the misuse of technology. Look, at the end of the day, it's Congress's job to make the law, and it is the court's job to interpret it. Earlier today on the Senate Judiciary Committee, we had an interesting discussion about criminal justice reform following a somewhat heated exchange between our chairman, Senator Grassley of Iowa, and our former colleague, now the Attorney General. I think the CLOUD Act is the right way to go forward, that it's been embraced by all four corners of the litigants and the centers of interest strikes me as some mark that it is exactly what we are trying to accomplish on the floor now, a compromise, which means not everybody's happy, but everybody's willing to live with it. And I appreciate your tolerating a few minutes of remarks from a senator who is about to run back and try and secure the last few votes for a bipartisan compromise on immigration. Rough-hewn, not what I would have written, but exactly the midpoint that if the president would simply hear yes, would actually move us forward on border security and Dreamers. So thank you. I hope you had a great panel. Apologize for delaying you.